I'm Blue Bailey.
And I'm Dexter DeNovo, and this is Reading is Fundamental.
The show where we talk about news in entertainment law.
Yes, that leather daddy
And that drag queen
are both licensed California attorneys.
We celebrate queerness,
Sex positivity,
and reading bitches for filth.
And with that being said,
The library is now open.
Officially.
The library is open.
Because reading is what? Fundamental.
The information on this podcast is for general information purposes only. Nothing in this podcast should be taken as legal advice for any individual, case, or situation. This information is not intended to create an attorney-client relationship. Sorry about it.
What?
Fundamental.
Hello, and welcome to another episode of Reading is Fundamental. My name is Dexter DeNovo.
And I am Blue Bailey, and we are coming, not live, but recorded from our studio in Burbank.
Yes.
Brought to you by Daddy Fleshbot.
Yes, thank you, Fleshbot. We are also joined by a very special guest today. Our very first special guest.
We're going to have my friend and brilliant First Amendment attorney Gil Spurline talk with us for our main challenge.
Yes.
But before we get into that...
Yes, I do want you to talk to me about Six the Musical, because you've seen it how many times?
I've seen it 3, and I've set 6 times that I want to see it. One of them needs to be on Broadway in New York. But I missed it in San Francisco. I saw it in Las Vegas. I became instantly obsessed.
Which time? The first time, obviously.
The first time.
Yeah,
yes. Like, I'm the type of person that I don't like to listen to a musical soundtrack before I see it, because I want to experience it all together. But I saw it in Vegas with my Nona. I instantly loved it. And then I'm like, when can I see this again? And there was this little pocket to see it in San Diego. So Sean and I saw it on Saturday. And then I decided to go see it again by myself on Sunday.
Again.
I'm already planning on seeing it in January in Sacramento.
So what is the musical about? I mean, it's like, I know it's the 6 Wives of Henry the someone.
It's very, it's very much in the genre of Hamilton, where it's...
Oh, it's like historical, but it's like rappy.
Historical rappy, but instead of rap, it's all women.
Okay.
And it's all pop music.
Oh, okay.
And the premise is that the 6 wives of Henry VIII get together to have a competition to determine who got fucked over the most.
You're like, well, I was beheaded, and I was
divorced, beheaded, died, divorced, beheaded, survived. It's amazing. You, as a divorcee, I think would love.
Wow!
Yes,
calling me out in my
you
trauma.
You as a divorced woman.
Wow!
Would love this musical.
Wow!
But it's amazing, and each of the songs is kind of influenced by a pop diva.
Okay.
So there's like a song that's like inspired by Beyonce, a song that's inspired by Adele, and they're each different styles of pop.
Okay, so we can have like a Britney moment.
Mm-hmm.
We can have like a Madonna moment, maybe.
I don't know about that, but
we don't.
Sure,
okay,
we'll go with
like
that.
Her. She's sick now and she's dead. We don't like her anymore.
But we have a whole drive back to San Francisco today. Where I am going to play you. I can play you the studio version of the soundtrack. We could play the live recording from New York.
God.
Yeah.
Why did we decide to drive down this time? Now I have to be stuck with you in the car.
Because it was cheaper and we don't make that much money.
2 ways to be stuck in the car with you both ways. I mean, I have heard good reviews about it. My partner went to go see it. You told me it was great. So, like...
It's amazing.
I guess we'll check it out.
It started to come out, I think... right when the pandemic happened, so I think all the press that was supposed to come out didn't really happen.
Yeah.
It won a Tony for best costumes.
That's it.
It's a legitimate Broadway musical.
It wasn't. It wasn't best musical though. It wasn't the Tony winning best musical.
Oh, it's not. I digress.
But the costumes are great.
The costumes are great. The songs are great. It's 80 minutes with no intermission. So
yes. Oh, 80 minutes no intermission.
Yeah.
Interesting. Speaking of good shows. I went to go see you in Bologna game show night in San Francisco. So Bologna's kind of like an all-male review show in San Francisco, run by, is it Coach Rory? Who runs
Coach Rory and Michael.
Which Michael?
Michael Phillips.
Michael Phillips. Okay. Yeah, and it's like I haven't been able to go to like the real one, but then they started
wow, shady.
Well, this is like an offshoot of the normal Bologna, yeah?
So it's Bologna is an all-male review, but because it's San Francisco, male is fluid.
Yeah.
So it's like a bunch of skits, and a lot of it is scripted, but we just started doing an unscripted version, which is a bunch of game show nights.
Yes.
So it's just like, normally during the scripted version, they'll take a break, invite an audience member up to play a game, and now there's a whole spin-off that's just the Bologna game.
Yes. So we did, so it is a spin-off.
Mm-hmm.
Yeah. I don't remember all the games. The one that you were in was like Kissing One or something?
Yeah, so I was in a game where we took an audience member up, we blindfolded him, and 3 guys made out with him, and then he had to guess
which one.
And I think this guy has made out with all of us before. He has made out with me because he
wow.
was able to identify
who hasn't.
Well, okay.
Oh, it's a person in the cast show. They probably made out with you.
Yeah,
maybe.
I get around.
And then, I mean, there were plenty of other games. It was a good time. I really liked it.
Yeah, there was like a bobbing for ducks and like splooge and like I don't know, like if you like, what is it, gunge? What's that, the fetish where you like messy food over you?
Oh,
that was there.
They did a whole bunch, but
my favorite was recreating an old porn scene.
Oh my gosh, yes, that one was the good one.
It was a scene with Brad McGuire and some other hot dude, and he was like, my daddy taught me not to rip the skin when I jerk off my cock.
Mm-hmm. It was so good. Well, like, the best part of it is that when they came on stage, like, the host was selling it as like, you guys, this is gonna be, we're gonna have somebody recreate an iconic moment in cinema. Like, this is gonna be something you're instantly gonna recognize. We're taltalking boom boxes holding over their head. We're talking like, you know, lady, any kind of like iconic movie moment, and then they play it and it's like really bad porn.
But it's iconic bad porn.
Yes, it's iconic bad porn.
The dude even has like that Yoda moment where he's like,
it was so bad. And then so like without knowing, they like got somebody they got one of the cast members on volunteer, took him away. They're like, you have 30 seconds to learn all of the lines, basically. It was probably like 4 minutes.
Yeah.
And then you're going to come back and then you're going to do the lines. And during that time, they showed said bad porn. And so everybody was laughing hysterically. And then they came back on, did the whole thing again. But it was cool because it's like, they were really trying. Like, they were like really going for it. And like that made it even funnier because it was like and then they brought their own interpretation to it too, which was like hilarious.
That Brad actually used to bartend at the Edge, and the Castro used to live in San Francisco.
Oh, nice.
But I've been like trying to break out of like just sucking dick on camera and get into like real acting. So I've been doing the unscripted Bologna.
Yes.
Hoping to get into the scripted.
Yes.
And I think kind of the split of scripted and unscripted is a great segue into our first mini topic.
Yes. Well, I will say, check out Bologna if you're in San Francisco. It's great. But yeah, like scripted and unscripted, that's a good segue into our mini topic, which is the actors' strike. Following shortly on the heels of the writers, I shouldn't say shortly. The writers' strike has been on for like 70 whatever days, but. The union representing more than 150,000 television and movie actors is now on strike. They're joining the screenwriters who walked out in May, and it's now Hollywood's first industry-wide shutdown in 63 years.
Yeah, I learned about this because I was scrolling through porn on Twitter and saw a clip of Fran Drescher yelling at people. I had no idea Fran Drescher was the president of the Screen Actors Guild.
Everybody at home, raise your hand if you knew Fran Drescher was. There was nobody. I had no idea.
One knew this. And she was amazing.
She's so good. I was like, okay, this is gonna be hilarious. And I saw like 4 interviews with her at this point, I think, about this, and I was like, oh my gosh. One, she's doing her job. Like, she's killing it. She's like really representing the union. She's like representing all the union values and everything. I'm like, you're doing a good job, and you're doing it in your own Fran Drescher way. So I was like, this is great. She's doing a great job.
Side note, I think Fran Drescher would be a great Snatch Game character. Not only can you pull from the nanny, but now you can pull from this speech, and you just got like so much material to go away.
And if you don't have an answer, then you can go on strike.
Yes.
And not have an answer. Yes. So both the actors and the screenwriters are demanding an increase in residual payments from streaming services. So like when this contract, similar to like when the writers, you were talking about the writer's strike, it's like when this contract was formed, I mean, streaming honestly wasn't even contemplated. Like these were decades ago. We didn't even dream of the fact that we can have like streaming internet coming into our homes and that it would just like you could watch something at the click of a button. But like lots of things have changed. It used to be that television series, like if it was a hit, then the actors would be able to collect residuals for a long time afterward.
And like residuals on 24 episodes of a season, not these little like 6-season Marvel shows and Star Wars shows.
Yes. I mean, the people on Friends made a lot of money eventually, but it's like what they were really going on at the beginning. It's like, okay, well, we had this 24 episode like arc, and then we're gonna get residuals every time the reruns play on the networks or anything like that. And there's no residuals for streaming, so it's like if you're on friggin' Yellow Jackets or whatever it is, you're not going to get any residuals anytime it airs on broadcast.
So that's like a common misunderstanding.
Go ahead.
People are throwing out shows like Yellow Jackets and Succession because, yes, they do stream on apps, but that's still traditional cable.
Oh, because it's HBO.
Yeah, so it's HBO that has like a companion app. And I'm sure they're not getting the residuals, or I'm not sure, maybe they're not, for streams that happen.
They're not required to.
But that's still like grounded in traditional cable.
Yeah.
I saw some weird thing about like some AI deal.
Oh my god! Okay, this is the craziest thing that got me. So like, our friend was like, the studios came back with an offer apparently that was like, so for background actors, we're gonna pay them for the day, and then we're just gonna scan them, and then we're gonna use their likeness again forever and always.
In perpetuity.
In perpetuity, forever and always. Like then you could just have it there. I was like, what?
It's exactly like that show on the first episode.
Black Mirror. You want me to watch it?
You should watch it. We should actually do a whole episode about if that's plausible or not. But it's about being able to scan someone's likeness and through AI have that person act, even if that person's not available.
Isn't that, I mean, I get it because it's like, okay, if you're a background actor and you don't have lines, it's like, okay, cool. But it's like, wow, we are really just trying to get rid of actors, aren't we?
But then also, like, what if you become big and then your, like, likenesses are...
Yeah, you can't just be signing away your likeness forever. Like, that's not, no.
I don't think this should be used in this context, but I would be very interested to see about, like, when actors die, about licensing their rights after the death. Because I thought it was really cool to see like Princess Leia brought back. And
yes.
It's really cool to see, like, even in the new Indiana Jones, I know Harrison Ford is still alive, but it's cool to see him like young. Maybe it would have been cool to have like Sean Connery brought in as like a
Sean Connery
artificial intelligence cameo.
Was that a good impression?
No.
I tried my hardest.
You're gonna like get eliminated on Snatch Game.
Wow, thank you. I mean, probably, but I think the difference between those two is like, okay, we're talking about fucking Carrie Fisher, like who's
established artist,
yes, who's like a big name and blah blah blah, and has leverage. Like a background actor who's like doing this for their job and like working all the time is. Like, they don't have that leverage. You know what I mean? It's just like, it's kind of just like take the contract as it is. You know, they're not going to be like, hey, actually, I don't want you to lose my likeness. They're just going to go to somebody else. You know what I mean? So
it's kind of like porn. Like, you have like, oh, you don't want to do this scene. You're not established. We'll just like find someone else who will do this and agree to our terms.
I think it's crazy. One thing that we immediately started thinking about when we heard this news is whether RuPaul is on strike.
Oh, yes. The most important thing is that All Stars 9 is filming right now.
Yes.
And I was very worried that it was going to get delayed because RuPaul is a SAG.
We were literally this weekend. You were going around asking everybody. You're like, okay, I know you're in the film industry. Okay, so SAG, is RuPaul SAG? Like,
yeah, is RuPaul SAG? Is it crossing a picket line for her to film? And I guess it's not, because it's unscripted television show. So I think like a SAG actor can still do unscripted television.
Okay.
And a lot of the mainstream studios are going to come, their fall TV series are going to be heavily reliant on unscripted game shows like Family Feud and stuff like that.
Yeah. It's kind of like similar. Well, yeah, I guess it would have been different. But
eventually we were talking about, like, could RuPaul just like charter a cruise boat and go film in the middle of like
I know.
Which is, like, not even...
Well, that became because you were sitting here, you and your conspiracy theories about everything.
Everything.
You have a conspiracy theory about everything. But you were sitting here like, oh, well, Bob and Alaska have been gone for 2 weeks, so they must be filming All Stars, All Winners. And then Bob was like posted something about being on a ship, and you're like, oh, they're filming All Stars, All Winners on a ship to avoid international law.
Yes. I am as crazy as a MAGA person, but only in the context.
But only for drag. the logic is there. It's just not good logic.
I love trashy reality television. So I definitely want writers and actors to be compensated fairly. But like, if this brings in a new dawn of reality TV, I'm okay with it. What I found interesting is that the Screen Actors Guild strike allows prohibits the actors from doing publicity appearances.
Yeah, well, it prohibits them from doing a lot of things, like tours, appearances, interviews, conventions, panels, like what the Barbie people are doing, even podcast appearances, which I was bummed about.
I didn't know about that.
Because I follow a lot of podcasts with like definitely SAG actors in them. But yeah, I think you were going to talk about something about the... can't go to. Oh, were you going to talk about press tours?
Yeah. So like,
like
Barbie, the press tours have pretty much happened, but there's going to be no more press tours. Oppenheimer had to cancel their red carpet, so they're doing nothing like as of the writer's strike. And then this could even implicate things like showing up to Comic-Con.
Oh yeah. That's like a
the
promotion.
Award shows like in the fall.
Yeah. I mean, okay, this is like totally. Allegedly, so we are not sued, girl. But like, we were talking to somebody this weekend, and they were like, "Oh, the studios asked for an extension on the negotiation deadline."
Oh yeah, so we have this on a very reliable source. And when I say reliable source, I mean someone that I know at Hot Dog Sunday yesterday.
Yes,
told us this
allegedly. That they asked for an extension on the deadline. And they're like, okay, we're going to give you the extension, blah, blah, blah. And they found out it was because they wanted to extend the time so that they can get all the Barbie press done.
Oh, okay. That's not what I was talking about. I was talking about the rumor we heard that the studios have basically stopped negotiating because they just want the writers.
Oh, to go. That was the writers.
To run out of money and starve and come back to the table.
That was the writers one, though.
Okay.
They're like letting the writers one sit right now. Yeah. And then the actors one, we heard they extended the deadline so that they could get all the Barbie press done.
Okay.
Which is shady boots.
That's fine. I'm excited about Barbie.
I mean, I'm excited about Barbie too, but it's like they're like using this negotiation tactic in order.
How many fucking Barbie dresses we've seen at these premieres on red carpets that Margot is wearing? The studio made the right move.
We needed the last black dress.
We needed that last black dress.
She has been killing it. Like literally every press thing. I mean, they're doing a tour, right? So it's like, I think they're doing like Mexico City and Tokyo and like all the things.
Well, not anymore, but they were.
Not anymore, they were. Yes. But she's been killing it every single time. And I think she's doing drag. Like the best thing about it is like she's doing this Barbie character, but if you look at the side-by-sides for each of like okay, this is Barbie's outfit, this is hers, she made it her own every time. Like it was like, you're obviously referencing this, but the hair's a little modern, you know what I mean? The accessories are a little different. Maybe the cut of the dress is a little different. So I'm like,
you're saying Margot Robbie should go on season 16?
She is probably there right now.
Yeah, and she's allowed to.
Because she's not SAG. Yeah. Because it's a non-scripted show. Yes, you could do that. She has been killing it. We will talk more about Barbie for sure.
Always.
Always.
Our main topic? What is our main topic?
Yes, our main topic today, we are talking about 303 Creative LLC versus Elenis, which is the Supreme Court decision where they decided to side with a website owner to allow them to discriminate against same-sex couples and refuse service to them on those grounds. But I will let our special guest give a better introduction because I'm sure he has varied opinions on it. So do you want to introduce our guest?
Yeah. So today we have First Amendment attorney Gil Sperline with us. Gil is an amazing attorney. We've worked together on some panels about adult entertainment and just for fan stuff. And I thought he would be a great person to come in and share his viewpoints and kind of explain the case for us.
I'm very excited.
Welcome, Gil.
I'm about to be heated too, so yay, Gil! Hello. Thank you for coming, Gil.
It's my pleasure.
This is amazing. This is my first time meeting you, so tell me a little bit about yourself and like what kind of work you're doing.
Well, first I want to know what makes me a special guest and makes me the first special guest.
Oh, I'm gonna kick that.
I'll just make that rhetorically.
She's special.
I'm very pleased to to be your first special guest.
Yes!
Especially since I just watched one of your podcasts with one of my clients on it. So I'm more special than him.
Oh.
So I'm an attorney. I've lived in San Francisco since 1994. The day after I graduated from law school, I moved to San Francisco. And I've been calling myself a First Amendment attorney for a long time, even though for a lot of that time I wasn't necessarily doing First Amendment work. And let me explain that a little bit. I worked for a long time doing a lot of work for the adult entertainment industry. Most of that work was doing copyright infringement work. In fact, I had somewhat of a reputation for when I was with Titan and representing them for being for somewhat doggedly going after infringers.
A ferocious litigator.
Yeah. Yeah, sure. So, copyright infringement is not First Amendment work. They kind of play off each other sometimes, but representing a disfavored speaker to me was in its own way First Amendment work.
For sure.
Because a lot of lawyers would not work for adult film companies. Mm-hmm. And so just representing them in anything, to me, part of the reason I did that is because of my commitment to free speech and to everyone being able to have a voice and to say or show the things that they want to show. So
amazing.
And then a number of years ago, I went out on my own. I still work for Titan and some other adult clients, adult business clients. But I do a lot more true First Amendment stuff now, which means representing protesters, school students that get disciplined for speech, defamation defense mostly, sometimes plaintiff side defamation. Any number of things. And I'm currently on the board of the First Amendment Lawyers Association. I've been in that organization for almost as many years as I've been a lawyer.
So I think one thing I wanted to start with this case is to kind of lay out the facts and kind of dispel some of the things that we've been reading about or hearing about. I think that a lot of people have been talking about this case as a discrimination case or an attack on same-sex marriage or something like that. And there's no topic or no conversation about the fact that this is about a Colorado law. So I wrote a little bit about it, and then I will ask you to fill in all the rest of the details. So sure. This is based on a Colorado law. So a Colorado law happened that said you can't discriminate on anybody if you offer goods or services to the public based on their sexual orientation. So there was this Colorado law that has been on the books, and this is a challenge to that law that rose all the way to the Supreme Court. It's about a Colorado web designer. She hasn't opened her business yet, but she brought a challenge to the Colorado state law because of her religious belief that she couldn't, in good faith, perform services for a same-sex couple. Now, how does that sound to you?
That sounds mostly right.
Okay. I'm trying to be unbiased too. Stefan had told me that we might have differing opinions on this, so I'm trying to
we have differing
opinions. I'm about to yell at her.
We're trying not to argue in the car.
We were literally trying not to argue about it on the car. But yeah, so I was trying to be as objective as possible in saying the facts. So they sound pretty good to you?
Yeah, there's a couple of things that I would add. One is that it's the Colorado Anti-Discrimination. It's like CADC or something like that. It's not strictly it doesn't strictly apply to sexual orientation. It applies to a wide range of protected characteristics, religion, kind of the usual lineup, including sexual orientation. So I think that's one important aspect because they're only challenging it based on this one law. And earlier you said something like the challenge was because they wanted to discriminate against gay and lesbian people.
Mm-hmm.
There's a little bit of semantics in here that I don't really go along with.
Yeah.
But technically, they have this case has a lot of stipulated facts. I want to get into that's created a lot of problems for me in analyzing the case, and also a lot of problems for people understanding the posture of the case, because it's been reported on somewhat poorly.
I would agree.
What they don't want to do is to be forced to make wedding cakes. That has nothing to do with not wedding cakes.
Wedding design, or like a wedding website.
Yes.
Yeah.
That goes to, there was an earlier case.
Yes.
That's very much connected.
And led to the Colorado law, yeah?
No.
Oh, okay, never mind. I went off there.
It challenged the same Colorado law.
Is it the same litigators too, right, though? It's the same, like, Christian, like, litigation group?
It's I don't know if they're named anywhere in it, but they're certainly the same group that, challenges these types of laws. There's no doubt that they're, kind of manufactured this or found a plaintiff. Another thing that I want to get into, which has been kind of misrepresented in a lot of places. And also, they brought this case before the other case had been heard or ruled upon by the Supreme Court. And in fact, the district court took some action, but then kind of put everything on hold until they heard from the Supreme Court in the Masterpiece Cake case.
Got it.
And once they punted, which people might not know this, but in Masterpiece Cake, they remanded it back to the trial court to answer some factual issues that weren't fleshed out. So.
Before we get into the First Amendment question, I had an issue or question about standing. It seems like the whole basis of this case is a potential client that has not even occurred, that ended up like being kind of fraudulent. Like the request that she received wasn't even from a gay person. So from like your perspective, how do we even get a case from that starting here? Like I remember in like, what was it, like Proposition 8, like that got thrown out because there was no actual harm to the group. So like, where is the harm here?
Hold on. Well, for the audience, we have to explain what standing is.
Oh, okay.
You said, I have a question about standing. What is standing?
So standing is having a harm done to you that allows you to bring a case into court, which this case, I'm not really seeing what that is here.
You can't just bring a case for no reason if it doesn't affect you.
Right. So, couple of things, and that's one of the things that hasn't really been, I don't think, presented correctly. So standing, what you're talking about, is the right to bring a case. The Constitution doesn't allow federal courts to give advisory opinions, so there has to be an actual case or controversy in order for you to sue. And to have standing, you have to show an injury, in fact, fairly traceable to the challenged provisions of law, and something that could be redressed by the court through whatever action, usually in these cases it's an injunction.
I love this like recitation of the elements. It's making me feel like very law school again.
That's hot. Keep going.
Yes, tell me the elements, Daddy.
I made notes to make sure I didn't just on that one. But so what happened here is called pre-enforcement standing to challenge a constitutional issue. And it's a really important aspect in free speech cases, especially, but also in other cases like abortion cases. So, and the last abortion case that went up before Dobbs, challenging the Texas law, got rejected mostly because of standing, for a different issue, not because of the plaintiff, but because of the defendant. I won't get into the weeds too much. I'll try. That law was specifically designed so that there was no state actor to sue. In most cases, if there's a law that's preventing you from speaking in a certain way, you want to have the ability to come in and challenge that law on constitutional grounds, in advance, because otherwise many people, rather than risk being censored or levied with fines, or in some cases prison time, or maybe a civil action against them, they need to know. And so they might just not speak their mind. They may avoid that area of the law. And I'm going to give you a couple of examples. So one is right now the Stop Woke Act in Florida is being challenged.
Oh God!
And no professor has been lost their job for teaching around issues of race or the other things that are that are banned. So those professors came in and challenged the law, and rightfully so. And then one that might be even more closer to your heart is Tennessee, I think it was Tennessee, where they brought a pre-enforcement action for the ban on drag shows.
Yes.
Otherwise, they wouldn't have been able to go forward because they couldn't risk the being sued or jail time or whatever it is. Each statute is different.
So we were like probably incorrect before, or I was, when I was like, oh, we have to wait for enforcement of the drag ban to see a case on it. So we could have a pre-enforcement, I forgot what you said it was called. Pre-enforcement challenge. Okay.
And the one in Tennessee was successful. The district court, a Trump-appointed judge, said this is bullshit.
Yes.
It's unconstitutional, and go ahead and have your, it was like a fundraiser, or like, I don't know if it was part of their gay pride, but they were able to go forward with their show.
Amazing.
So yeah, a lot of people, and I understand, because the way most of the left press described this was just this made up defendant.
Yeah.
Here it looks a little bit more suspicious, because this organization goes around and is trying to create facts, maybe, but even in that case, the Lambda Legal does that all the time.
Yeah.
Right now I'm bringing a case for the Free Speech Coalition, which is the trade association for the adult entertainment industry, challenging recent age verification laws that some states are.
Oh, for Utah, for the porn?
Mm-hmm. Yeah.
Yes, we talked about that on our podcast.
And I'd love to come back in and talk about those cases, because those I'm actually working on.
Work. Oh my God.
And so again, in those cases, all of these companies have to decide what they're going to do. Do they institute age verification, which is extremely expensive, and there's a lot of other problems with it, or can they go in and challenge it? So unfortunately, even the dissent in 303 kind of harped on that a bit, in a way that I think was a little disingenuous.
Interesting. Well, let's get into like the meat of the decision. So it's a 6-3 decision for the justices, written by Justice Gorsuch. And the main crux of it is he said that the government cannot compel speech. And he said that the decision is limited to creative expression based on the First Amendment. I was going to go just like a little background. So like when justices make decisions, the chief justice decides, all right, this associate justice is going to write the opinion of the court. And then it kind of circles around the other justices and they kind of tag on to it and say like, oh, okay, I agree with all of this or some of this or whatever it is. And then from that kind of coalition of minds, then the majority decision is made. So that's how that goes. But what can you tell me about Gorsuch's majority opinion, and like if it's right? I mean, this is a big question, but yeah, go for it.
Yeah. So just a little bit more on that process. Of course, the senior justice in the majority assigns which justice is going to write the opinion. So if it were, it's in a lot of cases, a lot of times it's going to be Roberts, right? Because if he's in the majority, it's either him or the most senior. He's not the most senior, but he is the highest ranking. And then the three in the dissent would have been the senior most judge, who would be Sotomayor, and she would have assigned it, and she assigned it to herself. The other thing I want to say before I get into my feelings about the case is to talk a little bit about my bona fides as a freak and an activist and progressive. We talked a little bit earlier. I represented sex workers who were challenging the California's anti-prostitution law. I represented the Castro nudists when they tried to challenge the law in San Francisco preventing them from being nude as an expressive act, which in some cases I think it is, some cases it's not. I went to law school in the early 90s in the middle of the AIDS crisis. I was an activist in the street, putting my life on the line. I always considered myself an outsider and a sexual outlaw. So I'm no conservative person who is.
That's why we love you.
Some of these opinions that express some support for what the court's decision was. So, what did Gorsuch make his ruling upon? Really, two issues. One is he found that this is expressive activity, and actually that wasn't even really a finding, because that was one of the facts that the trial lawyers stipulated to. I don't know why. There are usually when somebody does that, it's because they want to facilitate a ruling that's going to be dispositive, which means usually a summary judgment motion. So you guys know, but for those in the audience, when you have a case that's moving forward, if everybody agrees on the facts, then there's no trial. There's no reason for a trial. The trial's only purpose is to determine who's telling the truth or what facts are true. So if you stipulate to something, then the judge can just look at how the law applies to the facts in that case and make his or her decision. So here, all of the important facts were stipulated to by the parties. Let me mention some of them that are particularly relevant. All of the graphic website design services that the woman was providing were expressive, so covered by the First Amendment.
Okay.
Similarly, that they were original, customized, and let's see. The other thing that they stipulated to was that the viewers of the websites would know that it was 303 Creative's original artwork, which if we get into the weeds a little bit.
Yeah, I'm like, I don't know. It could be Squarespace.
Well, let's talk about that just a little bit. So the idea is it's expressive conduct, right? So it's speech. And by being, I don't want to use the word forced, but required to provide your voice, your creative activity to something that you don't agree with is a problem under the First Amendment. And again, I don't know how deep we want to go into the analysis. I have a really hard time switching between lawyers and lay audiences. So
we can help move things along. You said the first one was so like the first kind of prong of his decision was expressive activity. So it was like one, it was expressive activity, and then what was the other one?
The other one is there's a lot of different types of free speech cases, right?
Yeah.
So there's, licensing for like adult bookstores. There's pornography compared to obscenity. One is regulated, one is not, or one is banned and one is not. One is unprotected under the First Amendment. I got to use all the right terms. I'll catch shit from my colleagues. So if a law treats certain types of content differently, certain types of speech differently, then it has to that law has to serve a compelling governmental interest, and it has to be narrowly tailored. Those are the two prongs. Everyone agrees here that eliminating anti-LGBT bias is a compelling governmental reason, and that the government has a right to create these types of non-discrimination laws or public accommodation laws. The difference is on the question of whether it's narrowly tailored. And in compelled speech cases, it's a little bit different, even though that's the same analysis that is applied. A lot of the compelling speech cases don't even go through that analysis, so it's not clear, but they kind of reach the conclusion. So basically, the court's opinion is decided on a line of cases that says the government can't compel you to speak. And those cases are things like Barnett, which said that schools couldn't require children to say the Pledge of Allegiance, which, by the way, is one of the ways I wound up being a lawyer. When I was in high school, the ACLU came around with a little pamphlet that says, what your rights are, and it said I didn't have to say the pledge. So I decided to test that.
Amazing.
And got sent to the office, and my mother came to school, and she was crying that it was going to follow me everywhere, and part of my record and all this stuff. But it was so I've always been a little bit of a troublemaker.
And well, can I get into asking? So, let's get into what you believe.
Well, I have a question real quick on the least restrictive means, because to me, completely being able to reject the speech isn't the least restrictive. If you go to the website, couldn't you when you watch a documentary and there's always that title page, it's the views of the artist aren't necessarily the views of the studio. Having some sort of disclaimer like that to me seems least restrictive on speech. Why not that route?
Right. So part of the reason why not that route is what my real problem with the case is. I think the court, when you've given the facts that were stipulated to, I think the court came to the right conclusion.
Okay.
And just as a simple explanation as to why that is if you were a website designer, under this law, you would have to create a website for the Westboro Baptist Church, and you shouldn't be required to do that. And so it cuts both ways. One thing I want to make sure is clear: this case was not a religious freedoms case.
Yeah.
That was at the 10th Circuit. The 10th Circuit said that 303 did not have a case under the religious clause of the First Amendment, and the Supreme Court did not. They declined to hear that part of the case, so that 10th Circuit ruling stands.
I think that goes to your point that this case, there's been a lot of misreporting, because when I first encountered this case, I thought it was the religious right of freedom of religion versus this, but it's really the right of compelled speech, or not right to not compelled speech versus this.
That was a lot of at least left-leaning First Amendment lawyers' concern with the Masterpiece Cake case when that went up, because that went up on both religious and expression. And so we were glad to see it punted there. Here, we knew that wasn't going to be a risk, because these are the kind of cases that give more power to the religious clause, which I'm a First Amendment lawyer who specializes in expressive activity, not in free religion. So going back to your question about really the question is, and Sotomayor asked a lot of questions around these, both at oral argument and in her dissent. The reason that you want to protect speech is so that people can say what they want to say. But who is going to think that a website is, no one even going to consider who made the website, 303 Creative. They're going to think of that as an expression of the happy couple who is, represented within it. And to the extent that she wants her name behind it, that's her decision. It doesn't have to be that way. And so I think this was a horrible case in that it was agreed that this would be considered her speech. I think that's a question of fact that would be, first of all, difficult to decide in a preemption case because there's no facts to look at. But I just, that is really the struggle we're going to have after this decision, is deciding what's expressive and therefore protective of the First Amendment. We have two examples right now. We have baking a cake, and we have creating a website. The cake is conduct that can be expressive, which is protected in a slightly different way under the First Amendment than pure speech. So think of things like flag burning.
Okay.
Those cases are handled slightly different than pure speech, which is usually written words, spoken words, etc. So in this case, where there's words on a website, it's kind of hard to say that it's not speech. But I think the question to ask is whose speech is it? And that would have led to, I think, a different result.
So we're getting into about our last 5 minutes, but I still have a few more questions. So does this case set the precedent that if the speech is expressive, that it's automatically expressive of like the website creator? Does that establish that precedent?
Yeah, that's pretty narrow.
Okay. And what's the difference?
Maybe not even that, because it was a stipulated fact. What it says is that if it's expression, you can't be forced to, you can't be compelled to engage in it. So a website, is that going to be different from a speech? If you provide speeches for anybody, you open a business, I'm a speech writer, come in and apply, that's more clearly speech for people. It's an easier case. And I think in that case, you can see the reason why you would not want to be compelled to write a speech for somebody who you totally disagree with. On the other hand, and I don't mean to be dismissive, and I'll catch a lot of shit for this, but if this woman doesn't want to create websites for the gay community, who wants to go to her anyway? I mean, that's, again, it's very simplistic and flippant, but on the facts of this case, I'm not too worried, because everybody knows that straight people don't have very good artistic talent anyway. So who would want it?
That was my favorite thing about the whole case, is I saw a synopsis of what her website design services look like, and it was basically live, laugh, love, all over the place. Yeah,
it's pretty bad. I see it as very different from the original public accommodations laws were focused on housing and hotels and motels, because people in the South were not allowing African Americans to stay in hotels. Mm-hmm. That's a problem. And they made the same arguments then, but it's about it being, then it was freedom of association, and we should be able to, associate with only our kind.
Yeah.
The court struck that down in a case called the Heart of Atlanta Motel. And I think that was correctly decided, because that's not speech. And a lot of times people will make an argument that something is speech. They really try to kind of make that distinction, that argument. And that's where the challenges are going to be in the future. So I can't even think of what all the examples might be. We're certainly going to see more of these kind of cases, hopefully narrowing or cabining this decision. I don't think this decision really made any new law, because there's a case that involved, it's called Hurley, a case from a gay and lesbian pride parade, it was an Irish parade in Boston. It was put on by a private organization, and the gay and lesbian Irish club wanted to march in the parade. And the organizers wouldn't let them. And that went all the way to the Supreme Court. The Supreme Court said the parade organizers get to say what their speech is going to be. Parades have always been considered speech, pure speech. highest level of protection, and it was unconstitutional to compel them to allow the gay and lesbian group to march with them. And under that precedent, I don't see how you would come to any other conclusion based on the stipulated facts in this case.
Well, we want to thank you for coming on the podcast and chatting with us. We would love to have you come back and speak about the age verification laws that you're helping to fight against. So thank you so much.
Yes, this was great. Thank you so much.
It's my pleasure. It kind of flew by a lot more quickly than
it tends to. Yes.
A lot of speaking. So, if anybody wants to reach out to me and ask questions, I'm glad to follow up.
And where can they find you at?
My last name. If you do a search, it's pretty easy to find me. There's only a few dozen Spur lines in the country.
Awesome. I hope to run into you in San Francisco sometime.
Me too. We will.
Thank you.
All right. Sounds good. Have a good one, Gil.
Having me on.
Thank you, Gil, and thank you for joining us for another episode of Reading is Fundamental. Make sure to read your damn contracts, and we'll see you next time.
Bye.
Bye.
Because reading is what?
Thank you for joining us for another episode of Reading is Fundamental.
Be sure to like, comment, and subscribe so we can keep bringing you the show for free. As a reminder, Reading is Fundamental is brought to you by Fleshbot.com, the leading resource for gay erotica.
DM us with your comments, questions, and let us know what you want to hear.
Or you can email us at readingisfundamentalpodcast@gmail.com.
Until next time,
remember to read your damn contracts. Why?
Because reading is what?
Fundamental.
Fundamental.
Fundamental.